Minister of Justice and Correctional Services in another, also known as the Parole Judgment, found certain sections of the Principal Act to be unconstitutional and ordered the amendment of these sections by Parliament within a period of 24 months from the date of the order. Hence, honourable members, the amendments should be in place before the 3rd of May 2021. However, the court did provide a reading provision pending the amendment by Parliament. Let me not go more into the ball because I think the department has also provided us with a presentation that covers some aspects of what I would like to also say about it. But let me invite then the Deputy Minister to take over and to take us through the amendment bill. Deputy Minister.
Thank you very much, Chairperson. Chairperson and members of the Select Committee, good afternoon. We appear as the, yes, ma'am. We appear before the committee today as the Department of Correctional Services to appraise honorable members, firstly, on the proposed amendments contained in the Correctional Services Amendment Bill 2020, and to update the committee on public submissions received on the amendment bill and our responses thereto. The Correctional Services Amendment Bill was developed, as the Chairperson has indicated, to give effect to the Constitutional Court judgment handed down on 3 May 2019 in the matter of Opachipane Phahla versus Minister of Justice and Correctional Services and another. The Constitutional Court found certain sections of the Correctional Services Act, Act number 111 of 1998, to be unconstitutional and ordered the amendment of those sections by Parliament within a period of 24 months from the date of the order. The relevant sections of the Act must therefore be amended before 3 May 2021 in compliance with this judgment. Chairperson, we are aware that as the department, we should have tabled the amendment bill much earlier than we did. And we tender our apology for our tardiness in the hope that, important as the provisions of the bill are, it is short enough for it to be concluded within the stipulated time. It is necessary, though, for me to highlight that the sentences of offenders that stand to benefit from the Phahla judgment, as we call it, will still take effect from the date of sentence and not the date of commission of the offense. The date of the commission of the offense and not the date of sentencing will be used to determine the parole policy applicable. In other words, this means that lifers who committed crimes before 1 October 2004, but sentenced after that date, will be considered for parole after having served a period of 20 years, as provided in the previous Act, and not 25 years, as provided in the Correctional Services Act 1998. Towards the end of our presentation, we shall share the public submissions received from various persons and bodies and our responses and comments to these as a department. At the end of the day, we are here, Chairperson, to solicit the support of the Select Committee for the passage of the Correctional Services Amendment Bill 2020 by Parliament. At this point, I shall hand over to the department to make the formal presentation. Thank you, Chairperson.
Thank you, Deputy Minister.
I think it's Ms. Mlomo who is going to be making the presentation.
Okay. Are you writing the presentation this side, Ms. Mlomo, or Gershwin, are you doing that?
Chair, I've made Ms. Mlomo the co-host, so she can share the screen, but if she's unable to, I will assist.
Okay.
Good afternoon, Chairperson. Oh, I don't know whether I should show my face.
Please do. Please show us, you may show us your face. You can turn it off while you are doing the presentation.
Oh, I'm so sorry, Chair. It does not want to show my face.
Okay, no problem. Please continue. Are you able to project the presentation?
No. Let me ask the host to take charge of the presentation.
Okay, Gershwin.
Okay. Good afternoon, Chair. Good afternoon, members of the honorable members of the Select Committee. I'll be making a presentation on behalf of the Department of Correctional Services. My name is Vuyi Mlomondlov. I will go to slide. Let's go to the next slide. The next slide, the minister and the chair has already introduced it. Let's go to the next slide. Okay, the next slide, the summary is that this bill was developed to give effect to the Constitutional Court judgment, which is dated 039 May 2019. The Constitutional Court varied and confirmed an order of invalidity of the High Court of Section 136(1) and Section 73(6)(b)(4) of the Correctional Services Act, in that those sections were declared inconsistent with 3 sections of the Constitution. That is Section 9(1), Section 9(3), as well as Section 35(3) of the Constitution. Let's go to the next slide. Let me give a background with regard to this bill. The bill, next slide, please. Yeah. What's happening here? Okay. Oh, I'm sorry. Yeah. Okay, I'm sorry. Let me give the background. We do have an offender whose name is Offender Patla, who's serving a sentence of life imprisonment. Offender Patla challenged Section 136(1) of the Principal Act in High Court on the grounds that the use of the date of sentence rather than the date of commission of offense violated his right to a fair trial as contemplated in Section 35(3)(n) of the Constitution. Offender Patla also contended that Section 136(1) breaches his right to equal protection of the law and the right not to be unfairly discriminated against in terms of Section 9 of the Constitution. Offender Patla was convicted on 25 September 2004 for offenses committed earlier, but was sentenced only 5 October 2004. This meant that in line with Section 136(1), read with Section 73(6)(b)(4) of the Correctional Services Act, he was required to serve 25 years before he could become eligible to be considered for parole. Let me simplify this. Offender Patla was convicted on 25 September 2004 for offenses he committed before 1 October 2004. But on 1 October, a new parole regime, which was lengthening the minimum period to be served before a person could be eligible for consideration for placement on parole by the Correctional Services, by the Parole Board, so came into effect. Then Offender Patla challenged that, because if you look, he was convicted on 25 September, and then the parole, and he was only sentenced on 5 October. This means that if Offender Patla was sentenced before 1 October, he would have qualified to serve a minimum detention period of 20 years instead of 25 years. Then what's the court then did? The court held that the challenge provision, they breached the constitutional rights to equal treatment by the law and not to be discriminated against unfairly. The court also found that the challenge provisions amounted to retro application of the law, which violated the principle of legality. So what the judgment did, the the judgment includes a transitional provision that the Department of Correctional Services had to implement as part of the judgment. So that transitional provision is included in the second bullet. It says, any person serving a sentence of incarceration for an offense committed before the commencement of Chapter 4, 6, and 7 of the Correctional Services Act is subject to provisions of the Correctional Services Act 8 of 1959 relating to his or her placement under community corrections, and is to be considered to such release and placement of Correctional Supervision and Parole Board in terms of the policy and guidelines applied by the former parole boards prior to the commencement of those chapters. So in summary, what this provision is saying, any person who's affected by the conditions that are in the judgment, then with that person, we have to apply the old parole regime, which had a minimum detention period of 20 years. Then let's go to the next slide. So the Correctional Service Amendment Bill is addressing two issues, is the definition of the minister, and then Section 736A and Section 736B4, as well as Section 1361 and Sections 163A, which is the transitional provision. Then let's go to the next slide. Here, under the discussion, I've already explained about Pasha. If Pasha was sentenced before 1 October, he would have served a minimum detention period. He would have qualified to serve a period of 20 years before he could be eligible for consideration for placement on parole. So the main reasons that were advanced by the Constitutional Court for its judgment, it's that the rules governing the length of the period to be served in a correctional center before an offender becomes eligible for parole has the effect to either lengthen or shorten a term of imprisonment, which is a type of punishment. The court therefore opted for a broader interpretation of Section 35(3)(n) of the Constitution, so as to consider, at the very least, the legislated preconditions for parole eligibility to fall within the ambit of prescribed punishment. So I think let's go to C. In terms of C, the court found that the challenge provisions provided protection against retrospective application of a change in parole policy only to offenders sentenced before 1 October 2004. The provision left a category of offenders sentenced after 1 October 2004 for offenses committed before 1 October 2004 vulnerable to retroactive application of the law that affects them prejudicially. Then let us go to slide 8. Let's go to the next slide. So with the next slide, I will go to bullet E. Bullet E is one of the Constitutional Court provisions that are very significant in the judgment. Section 35(3)(n) of the Constitution provides that where the prescribed punishment for an offense has changed between the time the offense was committed and the time of sentencing, an accused person has the right to benefit of the least severe of the prescribed punishment. The court held that the impugned sections have the effect of imposing a more severe punishment in that the non-parole period is lengthier for those categories of offenders and accordingly declared it inconsistent with Section 35(3)(n). Let's go to the next, to the next slide. Then what then this implied is that the Department of Correctional Services has to implement the transitional provision which was included in the judgment. So in the process of doing that, the Department of Correctional Services has developed a circular and policies to guide the implementation of the transitional circular. Then the number of offenders that were found to be qualifying to benefit from the partial judgment, those that are serving life sentences, they are 1,690. Those that are serving determinate sentences are 885. But let me explain this. How does then the partial judgment applies? The partial judgment, what it does, it just, the department uses partial judgment to determine of the offenders that in our system, what is the date of the commitment of offense for these offenders, so that the department can then decide with parole regime to utilize of the two parole regimes that are in place. The department has got an old parole regime, which is informed by the old Correctional Services Act of 1959, and then the new parole regime that came into effect on 1 October 2004. So the date of commitment of offense is very critical to be able to decide which parole regime to utilize. The parole regime then, the difference between the two parole regimes is the minimum detention period that has to be served before a person is considered for placement in parole. The old parole regime, the minimum detention period is 20 years for the lifers. And then for the determinate sentence, it's a third. And then for the, and then after 1 October 2004, for the lifers, the minimum detention period that have to be served, it's 25 years before the offender is considered by the parole. So what the Department of Correctional Services did, not all our documents have got a date of commitment of an offense. Then the Department of Correctional Services communicated with SAPS in order to be provided with the dates of the commitment of crime. So the department communicated with the courts and the Department of Justice. And then the Department of Correctional Services has also changed its IT system in order to include the date of commitment of crime, so that if a person has committed crime in 1 October, the system can be able to determine those that are qualifying. Then let's go to the next slide. The interim arrangements. Okay, the department has commenced with the 3-year project to review the entire Correctional Services Act and its regulation. But priority is being given to matters related to parole in its entirety, the Judicial Inspectorate of Correctional Services, and the matters connected to the GBV. Then let's go to the next slide. Then the next slide here, we are then focusing on the responses that we have received through the process of obtaining the public comments. So we received a submissions from all the list that appears there. Legal Aid South Africa, African Criminal Justice Reform with Dula Oma Institute, Helen Suzman Foundation, Center for Applied Legal Studies, Ms. G.E. Mlangeni and Mr. M.G. Ibutelezi from Vryheid. Let's go to the next slide. The Legal Aid South Africa noted and supported the amendment bill. And then with the Africa Criminal Justice Reform, I will just summarize their inputs. The first one, the emphasis was that partial judgment affects the date of consideration for parole. It must not be seen as an instruction for someone to be released on parole. DCS concurs with that. The obligatory minimum detention period, which allows for the offender to be considered by the parole, does not mean that the offender will be automatically placed on parole. So even with partial judgment, that situation still applies. And then there's this issue that no issue is made with regards to the wording of the bill itself on its objects, but mainly raise concerns over a number of practical and technical issues as briefly listed. Those issues are listed in the next slide. So how we have responded here, it's that DCS is in the process of reviewing the entire Act and its regulations, which will include a total revamp of the provisions related to the parole principles and procedures. But if you also look at the bill, there are a lot of technical issues that have to be considered when you implement these two provisions. Then we said a lot of those will be catered for in the regulations. And in our appearance before the portfolio committee, then we were advised that those the regulations, they fall under the executive head. Then we will have to go and brief the portfolio committee because our regulations have to be seen addressing all the technical issues that are likely to affect the implementation of the Phahla judgment. So to ensure that there's uniformity, the Department of Correctional Services has committed itself that all the issues that were raised by the by the African Criminal Justice Reform and the Helen Suzman Foundation, they will be catered for under the regulations. Then let's go to slide 13. Slide 13, also there's a question on how many offenders are serving the terms of imprisonment for offenses committed prior to 1 October 2004. That question has already been addressed. I included it in the presentation. And then the other question was how many offenders are currently serving their sentences who have already become entitled to be considered for parole and have not yet been considered for parole. So here we're saying 802 lifers and 88 offenders serving determinate sentences are due for consideration and have not been considered, but the backlog is receiving attention as the parole board sitting are permitted to function in line with the departmental risk adjusted strategy. Then the other comment was that it appears that the dual parole system before and after 1 October 2004 will be in place for the foreseeable future. The Department of Correctional Services is noting this. The dual parole system, in fact, it's likely to stay over a long period of time unless a new judgment comes in, which will then replace the Phahla judgment. Because if you look at Phahla judgment, the key for determining whether you qualify for the Phahla judgment, that is for the application of the old parole system, is the date of the commitment of crime. So even if you are arrested now and convicted in this year or next year, if the crimes that you will have been convicted for were committed before 1 October, you become a Phahla case. So you will benefit in the Phahla judgment, even if you have not been charged. Now, if you are charged at a later stage, but the date of commitment of crime is before 1 October, you automatically become a Phahla case. Then let's go to the next one. I think we can skip this one. And then let's go to slide 15. So some of the things in that slide is the things that we are saying they are going to be catered for in the regulations. Yeah, so there was no need to include all those amendments in the bill. Yeah, because they are more specifics that should go to the regulations. Then let's go to slide 16. No, I think also with Helen Suzman, we had an agreement that a lot of issues that they raised, automatically those issues, they will be catered for in the regulations. I think let's go to slide 17. So under slide 17, the Constitutional Court judgment highlighted the difficulty raised by the use of the date of commission of an offense for determining the applicable parole regime in cases of continuing and multiple offenses. The bill provides no certainty on the applicable parole regime for offenders in these circumstances. I remember this one, we also addressed it. We said the issue of the offenders that are serving for multiple offenses whose crimes were committed at different period, that will be addressed also in the regulations that will be tabled by the department. And then let's go to slide 18, then the next slide. Then the Center for Applied Legal Studies, there is a need to define the process to be followed by the offenders and how those who become eligible for consideration for parole will be identified. These processes, because we are already implementing partial judgment, the current circulars, or I can say the implementation policies, they are providing guidance on how to identify people that should qualify, but we will ensure also that those details are included in the regulations. Then let's go to number 19. So here, it's saying the Act fails to explain the main reason for adding 5 years to the old Act for period to be served before becoming eligible for parole consideration. So here we are saying the Act cannot contain that. The Department of Correctional Services also, we have to understand why the Correctional Services has moved from 20 years to 25 years. So we are expected to tighten our parole. So the Department of Correctional Services has also been responding to the plea from the public that looking at the nature of crimes that are committed, we need to tighten our parole. So if you look, though we are tightening the parole, but if you become a parler, then that tightening is affected by the judgment. Okay, then let's go to slide 20. Slide 20, it's saying the Act and the bill must recognize that non-eligibility for parole is part of punishment to ensure that parole processes are fair, just, and transparent. Also to protect offenders' rights, especially the right to the least severe punishment when prescribed punishment change between time when offense committed and the date of sentencing. I think here we need also to understand that in as much as we do have the parole legislation, there are still also the provisions in the Criminal Procedure Act that guide how the Department of Correctional Services had to apply its parole. So there are provisions that are prescriptive of the non-parole period. So those provisions will be accommodated for, but everything will be clear once we put the regulations in place. Then let's go to slide 21. The periods of incarceration while awaiting trial should be included in the calculation of the minimum time to be served before becoming eligible for consideration for parole. I think this one, it's catered for in the Criminal Procedure Act. So I think we can skip it and go to 22. Slide 22, the minimum period, the minimum detention period should commence from the first date a person is incarcerated and not from the date when the offense was committed. I think here we agree with what Ms. G.M. Langen is saying, that the partial judgment, the focus on the date of commitment of crime, it just guides us to determine who qualifies for partial. So in order to calculate your minimum detention of period, we have to record the date when you commence with your sentence in the Department of Correctional Services. So there we agree with what the person is saying. And then offenders must be considered timelessly for placement on parole. All processes must be finalized 6 months before the date of becoming eligible for parole placement. This also is provided for in the policies of the Department of Correctional Services. We have to ensure that within the period of 6 months, in fact, 6 months before your appearance date, for consideration by the parole, all the requirements must have been attended to. Then let's go then to slide 23. Law regarding parole should be rewritten by chiefs of local villages in all official languages and in accordance with the wishes of the king and not in the terms of democracy. With regards to this one, unfortunately, the rule of law includes the Constitution, and the Department of Correctional Services for now is really following the processes that are determined by the legislature. And then the other one that was included was that the government must teach the law to all the people, and people must acknowledge the receipt of such training. People must also be provided with booklets containing the law. People should only be according to the law they were taught. Law must be more understandable for all people. We have taken note of this submission. Thank you, Chair. That's the end of the presentation.
Deputy Minister, do you have anything to add?
No, I don't have anything to add, Chairperson. We are ready. I think the department is ready to entertain any questions that may arise.
No, thank you very much, Deputy Minister Palamisa and Ms. Mlomo for that presentation. Members, as presented, the bill aims to amend the Principal Act to align it with the Constitutional Court judgment. Let me open it up then to honorable members. If you have any questions of clarity that you would like to ask, and if you can maybe just give me an indication by raising your hand. Okay. I'm not seeing any hand, but honorable members. Okay. Now, I'm not seeing any hand raised. So I take it, honorable members, that you are comfortable with the presentation, but also we should note, Deputy Minister, that this is just the start of a process in terms of us addressing this bill, and members of the committee will also be given opportunities to further deliberate on the bill. And we also note that the urgency of the bill in terms of the Constitutional Court deadline, and the reason we also wanted the briefing is the fact that we would also try to ensure that we take advantage of advertising this bill for public comment while we are on recess. But noting the timeline as well, honorable members, I know we are going on recess, but if needs be, we may also reconvene yourselves, possibly virtually, to try and then address the public comments that we receive on the bill. With that being said, Honorable Deputy Minister, thank you very much, yourself and your officials. We're going to continue with the rest of our agenda.
Thank you, Chairperson, but Mr. Msama seems to want to say something.
Oh, okay.
Honorable Msama. Yes.
Oh, Honorable Msama, my apologies. I did not see your hand.
Okay, Chairperson. Chairperson, ne ke batlo botsa gore hona le di levers tse di nang le more than 18 years, and di pampiri tsa bone ba re di le ko minister, and nako e ngata o thola ba re di pampiri ga di a fella, a gona anything e entsweng gore these people ba ka consider for parole or for gore ba ka ya for parole. Bothata go gore ga gona the life skill within their files, or ga ba ya for social development course like integration course, or ba biditse batho ba bo mofi gore ba kopane le bona. Ke batlo tseba gore this thing e tswa ke eng gore batho ba nne na go ka fitlang 18 years or feta 18 years go sempo go di pampiri tsa bone di tsamaile di buile, they were not right. Why di pampiri tsa bone di sai go NCC di feletse than gore di ebe di bua go sena nnete. Ke a leboga, Minister.
Thank you, Honorable Matsumai. Deputy Minister, were you able to understand the question in totality?
No, I was not. I
Well,
was not able, Chair. But I think maybe
You were not.
CDC remand detention might have understood it.
Okay.
I didn't understand.
I know it's broader than the current amendments we're dealing with, but if the CDC has understood it, I would propose that we get a response. But note, Honorable Mutsumai, that we are still going to further also engage the department in relation to this goal. And why, Deputy Minister, I'm saying perhaps if the department could respond to it, is because we don't, as a committee, we're a cluster of departments. So sometimes we don't have opportunity for certain kinds of engagements with the department. But if you would want to respond.
Thank you, Honorable Chairperson, Honorable Deputy Minister, and members of the committee. I actually did understand the question. The question has to do with the backlog in terms of the lifers.
Ms. Ma'am, are you able to increase the volume or speak in the mic?
Honorable Chairperson, can you hear me?
I can hear you.
Okay. I wanted to just respond with regards to the reasons for the delay in the submission of the profile reports. I'm trying to summarize what the Honorable was raising. It has to do with the reasons of the delay of the submission of the profiles, which includes amongst the social workers report outstanding, the psychologist reports, either sometimes it might be the sentencing remarks outstanding. As we are speaking right now, the department has put measures in place to address shortage of capacity that led to the delay, and the submission are currently at the NCC as we are speaking. There is also timelines that have been put in place, and we actually had a task team that has been working on dealing with those lifers that was affected due to the shortage of the skills that we are lacking. But however, there are measures that are in place that we have put in place, including addressing the social workers, the psychologists, and my colleague CDC has been running with that project. So hopefully it will be addressed in due course just now. Thank you.
Thank you, Ms. Mlomo. I think, Deputy Minister, as I was just indicating that I had concluded on the matter, but we are moving on to the second agenda item. You're welcome to be released from this briefing, but thank you very much to yourself and to the officials within Correctional.
Thank you very much. Thank you.
Our members, we'll be moving then to the second agenda item, which is the briefing by Legal Aid South Africa. And this briefing is on the draft amended regulations, which have been tabled in terms of section 23, subsection 2 of the Legal Aid South Africa Act 2014. I think present is the Executive Officer, Ms. Mantiti Kola, and possibly other officials from Legal Aid South Africa. I welcomed you earlier. But just note that this is also the committee's first engagement with Legal Aid South Africa. And yeah, please feel welcome to the committee today. Our members, without having to again also go into the regulations from Legal Aid South Africa, let me perhaps just indicate that in terms of section 23, subsection 2 of the Legal Aid Act, it requires that any regulations made under subsection 1 must before publication thereof in the Gazette be tabled in Parliament by the Minister for approval, and it implies that both houses of Parliament need to approve these regulations. So they've been tabled by the committee to process, and it is required of us to approve. But that being said, let me hand over to, I'm not sure, you're probably going to have to introduce yourselves as well. But yeah, let me hand over then to Legal Aid South Africa. You can introduce yourself and then take us through the regulations, amended regulations. Thank you. I think you need to unmute.
Yes. Good afternoon, everybody, honorable members. I'm Judge Muktamai Makume. I'm the chairperson of Legal Aid South Africa. With me today, I can see the CEO, Ms. Manti Tikola, the deputy chairperson, Mr. Nkosana Mvulela, I think he's also here. And we also have amongst our executive members, Mr. Patrick Unrumark, who will lead the discussions together with the CEO on this presentation. You will notice, honorable members, that as the chairperson has indicated to you, that this amendment to the regulations is being done in terms of Section 23(1)(2) of the Legal Aid Act. And we have submitted the draft amendments to the executive authority, being the Department of Justice. And they are the ones who are supposed then to present this to you, but we've brought our team here to then take you through the regulations. They cover a wide spectrum of amendments, which are in keeping with developments. We cover civil as well as civil regulation 9 in respect of the civil actions, and when also maintenance, domestic violence, harassment. We also deal with labor cases, divorce matters, and especially children's matters. And we also amend our means test and what happens to those people who are just on the borderline, who do not meet the means test, what contributions is expected from them. Having said that, I'll now pass it over to the CEO as well as to Unrumark. CEO, please come in.
Maybe before your CEO comes in, I was not aware that you had joined the platform, so I was a bit confused. Yeah, no, because when we had started, I don't think I noted you in the meeting.
No, that's fine. Thank you.
Welcome.
Thank you, Chair.
Please continue.
Thank you.
Thank you, Chairperson of the Board, and thank you, Honorable Chair. Good day to honorable members and also senior management from the DOJ. Like the Chairperson said, thank you very much for affording us the opportunity to take you through the proposed amendments to the Legal Aid SA regulations. The presentation, the Chairperson has already covered the first component of the presentation. My colleague, Mr. Patrick Unrumark, will take you through the details of each 9 regulations that we are presenting. And it's also important that we share with the committee that our executive authority, the Department of Justice and Constitutional Development, sought comments from several stakeholders on the proposed amendments back in September 2020, and the stakeholders were afforded a month up to 30th October to provide comments, and no comments were received. Overall, the proposed amendments to the regulations do not result in any significant policy change, and as a result, the Presidency Policy and Research Unit exempted our executive authority from conducting a socio-economic impact assessment on the proposed amendments. I'll then hand over to my colleague Patrick Hundemark, who is our Chief Legal Executive, to take the committee through and honorable members through the 9 proposed amendments. Thank you, Chair.
Thank you, Chair. Thank you, CEO. I see I don't have the ability to just share my screen. I see the screen is already there. So I will then just guide in terms of the pages. On the second page of the presentation, you'll see just the outline dealing with the introduction, enabling provisions, general, and the details of the proposed amendments to the regulations, as well as a conclusion. I think, Madam Chair, you've already alluded to the introduction and the first one, so I don't intend dealing with that again. And specifically the enabling provision, you've also dealt with that sufficiently, so I don't think I need to go through that. And it's correct that Parliament must then approve these regulations before they are gazetted. And our CEO has also dealt with the other item on page 8 of the presentation on the general and the seeking of comments. So I will then proceed to now slide 10 and 11, which gives a summary in a table form of the amendments that we are seeking and the reasons for the amendments, Madam Chair. So Regulation 9 and the details are contained in the subsequent slides. I'll go through the summary, and then if indicated from the committee that I should go through the details, I'll happily do so, Chair. So Regulation 9, really, we wanted to formalize a waiting period and prioritization practice. This is particularly so that with decreasing in resources and a high demand, that at some stages we do in matters give a waiting period of up to 3 months, where we have a system that tracks as to when we make an appointment for someone to come in for assistance. But obviously that's subject to the prioritization that we've also then included in the regulation, so that no one who's got a matter that's pending or that's urgent or that's about to prescribe doesn't get assistance. Then the amendment to Regulation 11 just really seeks to rectify a typographical error in the proviso, in that legal aid can only assist in claims that exceed the small claims jurisdiction by more than 50%. The wording was just slightly off and didn't bring through that intention clearly, so that in essence, the small claims court jurisdiction is currently 20,000. It will therefore mean we can't assist in matters where the claim is less than 30,000. Then Regulation 13. This is also just to confirm that legal aid is available to persons 60 years and older in maintenance, domestic violence, and harassment matters, even where the other party is not legally represented. Here specifically, it was not clear. It looked like the way it was worded that it could only be given in instances where the other party was legally represented, because it's one of the limitations that are in that clause. But it needed to clarify that where anyone's over 60, and that requirement is not specifically needed for any person over the age of 60. And then Regulation 14. We've removed the regulation insofar as it is that we would assist in the enforcement of Ccma awards. That is now particularly because the Ccma are assisting in the enforcement of their awards, and we engaged with them, and it was then confirmed that we would only render assistance where they were not able to assist in the enforcement of their awards, and where a legal practitioner was required to assist someone with the enforcement of the award. Then in terms of Regulation 15, this particularly focuses and looks at where we will focus our resources in terms of divorce matters, particularly where there are vulnerable clients who will suffer substantial injustice. And so we've set various criteria there where required to be met before we will be able to assist. The others then will either have to assist via self-help or via the registrars of the regional courts, who could assist them where we would find that in their matter there's no substantial injustice. Then on Regulation 23, this is once again just a technical amendment, also linking to the small claims court, clarifying that children can be assisted even where a claim falls within the jurisdiction of the small claims court. The wording there was just slightly off, that it looked as if we couldn't assist in small claims court matters for children. And so that's just to correct that technically. Then move on to slide 11, which I will then deal with Regulation 27. So Legal Aid South Africa, about 2 years ago, we came to Parliament for the increase in our means test. And we are now suggesting that we make provision for an automatic annual increase in the means test threshold by the Consumer Price Index. So what this means is, without us every year having to come back to seek to increase it, that CPI automatically be applied to these amounts, and therefore that our means test will keep pace with the increase in inflation, and thus the increase invariably in salaries of applicants seeking legal aid. Madam Chair, Regulation 31. So until now, only partially subsidized legal aid was available in criminal matters. And we felt that it's a time to look at that in civil, that we include civil matters in partially subsidized legal aid. So where an applicant exceeds the means test, but we feel that they're not able to otherwise afford the cost of their full cost of their legal representation, that we look at providing assistance, but subject to them making a contribution. And then Regulation 32 is really then just a consequential amendment that makes provisions for contributions also to be levied in civil matters where the means test is exceeded. So that's in essence where you find someone is involved in a matter, particularly women, you find they're maintaining the children, they're getting no assistance, and yet they need assistance in sometimes they're in a contested divorce and they're not able to afford it because of all their other expenses, that we can assist them, but then just require them to make a contribution. So, Madam Chair, that is the summary of the details in terms of the proposed amendments to the regulations. I will be guided by Madam Chair as to whether I should go into the detail or not.
Please go into the detail. As I've indicated, this is also our first engagement with the sixth term Parliament as this committee with the legal aid. Please continue.
Thank you, Chair. So then I'll move on to slide 12, which then deals with specifically Regulation 9, and as you can see, the current wording, and in dark is the wording that, or in bold is the wording that we intend to add, so that we can grant legal aid with or without a waiting period. And then also then in addition to the sub-regulation 6, that where we do apply a regulation, we must prioritize civil matters which have a significant impact on clients' lives, including but not limited to civil proceedings involving children, because that's a requirement in terms of Section 28(1)H, evictions, social security matters, education matters, and income-related matters such as employment or dismissals, pension and related funds and maintenance, so that those will receive priority in terms of assistance without a waiting period. Then I'll move on to slide 13. That basically sets out the reasons for that amendment. We already do apply waiting periods, and this amendment therefore just seeks to confirm that practice. And then, as I said, that Regulation 6 just applies for which matters must be prioritized when a waiting period is applied. I will move then specifically then in terms of Regulation 11. This is, as we mentioned, this links to the small claims court and is into sure. So we replace the Regulation 11 sub 3 with the paragraph that is then in bold, specifically to make it clear that we can only insist in matters where the claim exceeds the small claims court jurisdiction by more than 50%. So that's, at this stage, the small claims court jurisdiction is 20,000 Rand, which would mean any claim 30,000 and above that we would be able to assist with. Then I'll move on to slide 15, which deals with Regulation 13. And this then deals specifically the whole sub-regulation 1 is replaced with this sub-regulation that deals with the issue of rendering of legal services in maintenance, domestic violence, and divorce matters. So, and this flows then on to slide 16, where we then change sub-regulation 2 to make it clear that we can only grant legal aid or legal representation in a court hearing matters 13 sub-regulation 1 if, in the opinion of Legal Aid South Africa, the legal aid applicant's claim or defense has good process of success and the opposing party is represented by a legal practitioner or is a legal practitioner, or the legal aid applicant is over 60 years of age or disabled. So we've brought that in there to make it clear. It previously appeared in sub-reg 1, and then it read as if, even if you were 60, you had to then, you could only get assistance if the opposing party was legally represented. So we've brought it down into sub-regulation 2 to make it clear that persons over 60 can qualify irrespective of whether the other party is legally represented or not. So the aim is obviously then to ensure that we assist vulnerable persons, persons aged over 60, and vulnerable persons, even where the other party is not legally represented. And this will then enable disabled and elderly persons to be assisted, and particularly due to limited resources, that we would want to then focus those resources on the elderly and disabled. Then we're moving on to slide 18. This is then regulation 14, where previously we assisted with the enforcement of CCMA awards. We found that there was a duplication of services, and thus felt that we shouldn't duplicate services presented by the CCMA, who also then assist with the enforcement of their own awards. And in consultation with the CCMA, we felt that we will amend that to then only provide assistance in instances where they were not able to successfully execute in terms of matters, and the applicant who received the award is then assisted to enforce the award. You sometimes find in those instances, the examples will be where companies move, they disappear, and then you've got to try and trace them and see if you can find them, or they change partners, or they change names. And then you have to bring applications to then make sure that the award can be enforced against them and that they aren't able to hide from the applicant who received the award. So that is then, and then slide 19, I would have just dealt with that overall. That was the basis of the proposed amendments, so that we avoid that whole issue of duplication of services and focus it on where the CCMA is not able to ensure that the award is enforced. Then I move on to slide 20, which is then dealing with regulation 15. So this is specifically then dealing with divorces, and we're setting out here in matters where we're not able to grant legal aid for divorces, and particularly we don't assist in divorce appeals or a divorce action if the legal aid applicant married a foreigner to enable the foreigner to obtain South African citizenship, so a marriage of convenience. And then we've added, in essence, a divorce action where there is no allegation of domestic abuse, no child, including a disabled or intellectually challenged child, no immovable property as part of the joint estate, no pension interest as part of the joint estate, or any other substantial benefit in the joint estate. So any divorce that doesn't meet any of those criteria, we would not be able to assist with. There will be self-help. We do make it available via our paralegals, or also then via the registrars of the regional courts, who can assist in necessarily completing the necessary papers for divorce. In that way, we find where you don't have any of these factors, the complexity level of the divorce would then enable someone to be able to ensure that they get their own divorce. So that specifically is for us to make sure that we focus our resources Due to budget cuts, we have now resources and we have got resource constraints. Our ability to take on new matters is currently at about 46,000 a year, but with reductions in numbers, we must probably reducing down to about 40,000 matters in the year, and therefore we've got to be able to manage what we make available from a legal aid perspective. Then in terms of, I'll move on to next slide, slide 22, which deals with Regulation 23. Once again, this deals though with the children's issues relating to the small claims court, where we've changed the wording of Regulation 8 to align to that which is reflected in bold, which makes it clear that we're able to assist children in claims even where the claim does not exceed the jurisdiction of the small claims court. So this is just a technical amendment. This is how we actually deal with the matters, but in terms of the original wording, just didn't align to what was happening in practice. So just to ensure that we align it and that the regulation aligns with what we actually do. Then I'll move on to slide 23, which deals with Regulation 27. As I mentioned, so in terms of Regulation 27, the amounts referred to in sub-regulations 2, 3, 4, 5, and 6. From a Legal Aid South Africa perspective, we have a means test, and the means test has, in essence, we look at both income and we also look at assets. The fact is that you don't have an income or you fall within our income band doesn't necessarily mean that you don't have assets with which you are able to, for example, afford your own costs of legal representation. But what we felt is, in terms of this provision, instead of every year or every 2 years having to return to Parliament to adjust the means test and then to delay the increase, is then to automatically increase it by CPI, as announced by Stats SA, and in that way to implement that Andy on 1 April, that will align with the new financial year, but then to adjust each of those amounts in those subsections then by CPI, and thereby keeping pace with any changes in inflation and therefore also increases in salaries. Then on to slide 24, deals with Regulation 31. So this is where we now introduce the issue and we remove the word relating to providing partially subsidized legal aid only in criminal matters. We've removed that subsection that only referred to criminal now, and to remove that reference, and therefore it opens up the regulations that we're also then able to assist in civil matters where it meets all our other requirements in terms of Regulation 9.1, to assist then with partially subsidized legal aid, so not fully subsidized, partially, and that we will then levy a contribution. This then opens it up, obviously, to civil assistance, where we're finding we do get applicants that exceed the means test, but would be able to make a contribution, but are not able to afford the full cost of their legal representation, and thus opening them up to prejudice in any matters they may be involved in. Then the last amendment is slide 26, which is Regulation 32. So here we bring in the issue of contributions, and then as Regulation 32 only provided for instances where in criminal matters came to an end, how we would deal with this. This is a consequent amendment to ensure that in terms of Regulation 32, now it provides for the situation where a civil matter is finalized, that then the contribution will stop at that stage, and therefore to set the conditions in terms of which partially subsidized legal aid can be provided in civil matters. So, Chair, that is obviously the overall in terms of the envisaged amendments to the current regulations. So in essence for us, it doesn't result in a significant policy change in that we are just adjusting certain issues. There are technical corrections that we are seeking to align the policy with the actual position. We're also limiting and with our limited and decreasing civil resources, we will then direct what we do have available to the most vulnerable. And there will also not be a duplication of services between what the CCMA assists with and what Legal Aid SA assists with, and then ensuring that the means test keeps pace with the change in inflation rates, and therefore not having to continually come and seek revisions to the regulations. But obviously only these regulations will only come into effect once approved by both houses of Parliament and then duly gazetted by the Minister. Thank you, Madam Chair. That is the presentation. I'm not too sure we can then seek questions. Thanks very much.
Thank you very much, Board Chairperson and your team for the presentation. Honourable members, I'm going to open it up for operation. If there are any members who would want to ask any questions for clarity and or make a comment, please, if you can give an indication. If you're able to raise your hand, please do. If you are not able to do that, please just give me an indication. Okay, I'm not seeing any hand being raised. Honourable Motsamai, are you? Okay, no, there's no hand that is being raised. Maybe the reason I'm calling out for Honourable Motsamai is because he tends to ask a question when I'm concluding the session. So yeah, he might have fallen off. But maybe just if I can just ask perhaps two questions. I think the one relates to your Regulation 15, subclause, the amended version of sub-regulation 2, where you indicate that legal aid may not be, you may not grant legal aid for a divorce action. And the circumstances being that if the legal aid applicant is married to a foreigner, to enable that foreigner to obtain a South African citizenship. And the reason I'm asking this question, and maybe I want more clarity, while you have indicated that the issues might be complex, the complexity of the issues also what determines what you focus on, or the non-complexity of the issue. But your focus is to provide legal aid to vulnerable persons. And if anything, in these kind of circumstances, we find that it is vulnerable women and or vulnerable families that are on the receiving end of this practice. And perhaps maybe if you can just clarify that a bit more or give more information on that. And my second issue relates more to the fact that your resources are dwindling. And I think the fiscal environment in which we find ourselves in, yeah, I don't see increases in budgets in the near future. But with these decreases in the resources, will you be able to then also implement these regulations as amended? I think those are my two questions. I still don't see any other member raising a hand. So if Board Chairperson, if I can maybe hand over to you then. Thank you very much. You need to unmute yourself.
Maybe Patrick should respond. Mr. Wundermark.
Thank you, Judge. I don't know if Tia wants to come in first, but I'm happy to respond.
Okay. Yes.
Thank you, Chair. Thank you, Madam Chair. I think with regard to the question that relates to the dwindling resources, legal aid, like all government entities, is faced with mandatory budget cuts. We are looking at, with the year beginning in April, looking at about 182 million reduction, of which 100 million is on compensation of employees and 81 million is on goods and services. For the next MTEF year, we're looking at about 230 million, and the subsequent one, the outer one, we're looking at 121 million. Over the MTEF period, we are to reduce compensation of employees by 225 million, and that would invariably have an adverse impact on our extent or the delivery of services. In terms of the proposed regulations, we will be able to fulfill them in the sense that with regard to our civil delivery, we have already introduced the waiting periods, and also we are prioritizing in terms of what we are proposing in terms of the civil delivery legal aid. Like we said, the proposed amendments to these regulations is just to afford more clarity as to which services, under which circumstances we offer them. They are not a significant deviation from the existing policy. Thank you, Chair.
Board Chairperson, you need to unmute, please.
But before Patrick comes in, maybe to deal with that question on representation of the divorce matters where a person married to a foreigner is automatically excluded. But if the intention of the marriage was to defraud the law and to enable a person to acquire citizenship where he would not have acquired citizenship of the country, then in that event, that person is excluded. I think we've had a number of examples in our courts about those instances where people have just of convenience in order to enable them to bypass immigration or the refugee laws or other things. And in those instances, I think they'll be excluded. But otherwise, if the marriage was genuine and it was with the intention of a union, a long-lasting union, then that person is not excluded. Patrick, I think you can add up to that.
Yeah, thanks, Judge. I think you've dealt with it correctly. The limitation, particularly what we found, is where there's these financial transactions that have taken place. The parties actually never live together. They get married and get citizenship. It's been merely a financial transaction. And you're correct. It won't exclude somebody where there's been a genuine intention and then maybe someone has absconded or left or other difficulties. We found that has happened. But where it was genuinely entered into without that, absolutely there will be assistance. And I also think you also get those that are the fraudulent marriages, but that's a separate thing. That's not a divorce. That is then where you're seeking to set aside, and we're busy with a project currently with the Wits Law Clinic, where we're assisting a large number of women where they didn't get married, but on the Home Affairs registers, it shows them and reflects them as being married to foreigners. But there we're setting aside all those marriages, particularly, and there are applications that we will be bringing in those matters. So it doesn't include those kinds of circumstances. I think you've covered it well, but the concern for us is particularly where that was done for a financial purpose and with that very clear intention to defraud for citizenship.
And Patrick, maybe you could also what the issue where if in such instances where children are born, what is the position of those children? The intention was originally to bypass the law on immigration and that, but children get born. What is the position there? Will those children be excluded? Maybe you could just inform the committee about that.
No, Chair. Obviously, children born here of one of the parties that's South African or born in South Africa, regarded as South African. And so assistance to children, specifically in relation to what their needs are, will not be excluded on that basis at all.
I Thank you very much for those responses. I see members are okay for now. Let me just take this opportunity then to thank you very much to the board chairperson, as your colleagues from Legal Aid South Africa for the presentation and for the responses. And maybe just indicate, honourable members, we will, in a subsequent meeting, perhaps deliberate further on the amended regulations, and obviously then also take a decision by the committee on approval of or not of these regulations. With that being said, Chairperson, thank you. I mean, the board chairperson, thank you very much, and thank you very much for your team. As a committee, we're actually going on our third agenda item, which is dealing with our previous minutes. So you're welcome to also leave the platform. Thank you very much.
Thank you very much, Chairperson and honorable members. Thank you.
Thank you, Madam Chair and members.
Thank you, Madam Chair and honorable members.
Thank you. Honourable members, we're going to our third agenda item, which is the adoption of minutes. We have 4 sets of minutes that we'll be looking at. The first set of minutes is dated the 8th of December 2020. And in terms of this meeting, honourable members, we received a briefing from the IEC on the Electoral Laws Amendment Bill, and we also considered and adopted, I think, a lot of the outstanding committee minutes. I think in terms of attendance, all members were present in that meeting. And members, as the minutes are also reflected on the screen, they were also sent to you. So I'm going to assume that you've been through these minutes, but essentially the meeting dealt with the briefing that we received on the Electoral Laws Amendment Bill and our deliberations on that. Members, maybe I'll just see if you can maybe give me an indication on whether there are any additions and or amendments you want to make to the minutes, and if not, whether you would want to move for the adoption of the minutes. Honourable members. Honourable members.
Fine, Honorable Chair.
Chairperson. Okay.
Okay. Honourable Bartlett.
No, I'm fine, Honorable Chair.
Are you moving for the adoption?
I'm moving for the adoption of the minutes, Chair.
Okay, and a second, Honourable Mposi.
Thank you, Honorable Chair. I second the Honorable Bartlett for the move of the
I second it, Chair.
Okay, so we've got, so the minutes are seconded. Are there any objections? Okay, then let's honourable members, I'm going to move on to the next set of minutes, which is dated the 10th of February 2021. I think in this meeting, honourable members, all honourable members were present, but it was the meeting that did not take place because we were going to deliberate on the responses by the Independent Electoral Commission on the written submission on the Electoral Laws Amendment Bill. And in that meeting, I think we identified some discrepancies in the minutes, in the some number of submissions, and then we requested the department and the parliamentary and the committee to then just look into the realignment of the numbers and then to make a resubmission to the committee. So, honourable members, do you have any additions that you would want to make to those minutes, or would you want to move for the adoption of the minutes? Honourable Tetwa moves.
Honorable Kosi seconds.
Thank you, honourable members. minutes of the 10th of February are adopted. I'll then move on to the minutes of the 17th of February. Honourable members, this is when we received the responses and presentation by the IEC on the written submissions on the Electoral Laws Amendment Bill. And in this meeting as well, I think all members were present and we deliberated quite extensively on the minutes. Members, I want to again assume the minutes are read. Are there any additions you would like to make and or amendments? And if not,
Chairperson,
Honourable Nkosi.
Nkosi, I move for the adoption of the minutes, Chair.
Thank you, Honourable Nkosi.
Tetra second.
Thank you, Honourable.
A second, Chair.
Thank you, Honourable Mteto. Our members will then go on to the final set of minutes, which is dated the 24th of February. I think all members were present in this meeting, and Honourable Ngwezi from KZN, it was his first meeting as well with the committee. I think in terms of this meeting, we deliberated on the Electoral Laws Amendment Bill and the adoption of the committee report in that meeting. Our members have got us these minutes are quite long as well, so I'm going to assume that they have been read. If you can give an indication whether you have any addition or amendment that you would like to make. If none, if you can then move for the adoption of the minutes.
I move, Honorable Chair.
Thank you, Honorable Bartlett. And if I can get a second.
I second Honorable Nkosi, Chair. I second Honorable Bartlett.
No, thank you very much, Honorable Nkosi and Honorable Bartlett. So the minutes of the 24th of February are also duly adopted. With that being said, honourable members, we've come to the end of our agenda. And let me then just take this opportunity once again to thank you for your attendance and or participation in this meeting. And let me also declare this meeting closed. Thank you very much, honourable members.
Thanks, Chair.
Honorable Chair, thank you so much.
Thank you.
Thank you, honourable members.